The Supreme Court has criticized Baba Ramdev and Patanjali Ayurved for misleading advertisements promoting Ayush treatments which undermine modern medicine. The court has issued contempt notices against Ramdev and Patanjali's managing director Acharya Balkrishna for persisting in distributing misleading health cure advertisements despite previous warnings. The court has also questioned the government's inaction against Patanjali's violations and emphasized the seriousness of the issue. The question stands: how far is this aimed at? Hi everybody. The case revolves around Patanjali's Ayurved's misleading advertisements promoting Ayush treatments which undermine modern medicine. These advertisements allegedly made unsubstantiated claims about the effectiveness of Patanjali products in treating various health conditions, including serious illness like heart conditions and asthma. The Indian Medical Association raised concerns about the dissemination of misinformation and the degradation of modern medicine by Patanjali, leading to a lawsuit filed against the company. The Supreme Court criticized Patanjali for persisting in distributing such misleading advertisements despite previous warnings, prompting contempt notice against Baba Ramdev and Acharya Balkrishna, the company's managing director. Talking about the regulatory compliance, let's firstly understand what are the legal and regulatory frameworks governing advertisement practices in the healthcare and wellness industry in India? How did Patanjali's advertisement violate these regulations? In India, advertising practices in the healthcare and wellness industry are regulated by various legal and regulatory frameworks to ensure the protection of consumers and the integrity of healthcare products and services. Some of the key regulations include: number 1 is Drugs and Magic Remedies Act 1954. This legislation prohibits the advertisement of drugs or remedies that claim to have magical properties or falsely represent the nature or efficacy of the product. It aims to prevent the dissemination of misleading information to the consumers. Number 2 is the Consumer Protection Act 2019. This act provides for the protection of consumers' rights and interests, including the right to be protected against unfair trade practices and misleading advertisements. It empowers consumers to seek redressal for grievances related to deceptive advertising. Number 3 is the Advertising Standards Council of India. The unit is a self-regulatory organization that monitors and regulates advertising content across various industries, including healthcare and wellness. It issues guidelines and codes of conduct for advertisers to ensure that advertisements are truthful, fair, and not misleading. And number 4 is the Food Safety and Standards Authority of India. The Food Safety and Standard Authority of India regulates the advertisement and labeling of food and dietary supplements to ensure compliance with safety and quality standards. It prohibits misleading claims or representations regarding the nutritional value or health benefits of food product. Patanjali's advertisement violated these regulations by making unsubstantiated claims about the efficacy of its product. Such claims were not supported by scientific evidence or clinical trials, thereby misleading consumers about the product's effectiveness. Going ahead with the government intervention, let's delve into what role should the government play in regulating advertising practices in the healthcare industry to protect consumer interests and ensure compliance with standards. How effective are existing regulatory mechanisms and what reforms could be implemented? The government's role in regulating healthcare advertising is pivotal for safeguarding consumer interest and ensuring compliance with standards. Key functions include enacting and enforcing regulations, oversight, collaboration with stakeholders, and public education. Regulatory agencies such as the FDA monitor advertisements for accuracy and adherence to guidelines. Existing regulatory mechanisms vary in effectiveness across different countries and regions. In some cases, regulatory agencies may lack sufficient resource, expertise, or enforcement powers to rapidly monitor and enforce advertising standards. Additionally, the rapid evolution of advertising platforms and technologies present ongoing challenges for regulators in keeping pace with emerging trends and practices. To enhance the regulatory effectiveness and protect consumer interests, several reforms could be considered. Number 1 is strengthening regulatory oversight. Governments can allocate additional resources to regulatory agencies responsible for monitoring and enforcing advertising standards. This may involve hiring staff, investing in training and capacity building initiatives, and enhancing collaborations with other government agencies and international counterparts. Number two is enhanced transparency and accountability. Governments can promote transparency and accountability in healthcare advertising by requiring advertisers to disclose information about the evidence supporting their claims, such as clinical trial data or scientific studies. This can help consumers make informed decisions and hold advertisers accountable for the accuracy of their claims. Number three is promoting self regulation and industry standards. Governments can encourage industry self regulation by supporting voluntary codes of conduct, certification programs, and industry standards for healthcare advertising. This collaborative approach can complement government regulations and foster a culture of responsible advertising practices within the industry. Number four is consumer empowerment and education. Governments can invest in consumer education initiatives to empower individuals to make informed choices about their health care. This may involve providing resources, tools, and guidance on how to critically evaluate healthcare advertisements, recognize misleading claims, and seek reliable information. And number five is proactive regulation of emerging technology. Government should proactively regulate emerging advertising technologies such as online advertising, social media influencers, and mobile applications to ensure compliance with healthcare advertising standards. This may involve updating existing regulations, developing guidelines specific to digital advertising, and monitoring emerging trends and practices. Hope you liked the video. Let's unlock together your full potential and achieve remarkable success in the world of business. If you are new to the channel, do like, share, and subscribe for more such content related to business and finance. Till then, goodbye everyone.